Good day, Mr. Hasharan. I am Ivan Leong. In this video, we will be discussing several crucial matters regarding the ongoing dispute between Heavy Lifting Builders Plc, aka HLB, and Charlie's Block and Tackle, aka CBT. We will be advising HLB on their rights against CBT in this video.
Good day, Mr. Hacharan. This is Vinny. To establish the basis for a potential legal claim, it is important to understand the requirements of actionable misrepresentation. Under English law, there are 4 elements to be fulfilled. It must be an unambiguous statement of fact or law, it must be false or untrue, and it must have been made known to the party misled before or at the time the contract was made and thus induce the innocent party to enter into the contract. On the first requirement, that it must be an unambiguous statement of fact or law, to determine if CBT representations amount to actionable statements of fact or mere opinions, the case of Smith v. Land and House Property Corporation, 1884, is relevant. According to this case, if the facts are not equally known to both parties, a statement of opinion by one who knows the facts best can imply a statement of material fact. In this scenario, Charlie, being the proprietor of CBT and having access to the relevant manuals, had better knowledge about the crane's capabilities than HLB's engineer Bob. Therefore, Charlie's representations can be seen as statements of fact. Moreover, the case of Dick Bentley and Harold Smith Motors Limited 1965 established that a representative statement whose expertise was reasonable for the buyer to rely on is a warranty. Although Charlie is the sole proprietor of CBT who sells heavy-duty cranes and thus has the expertise, nevertheless, the written contract did not state the tonnage capacity of CBT-3 cranes. Therefore, it is not a term of the contract rather than a statement of fact.
Hi Mr. Harcharan, I'm Yogita, and I will be continuing on the aspect of duty of disclosure. When establishing the elements under misrepresentation, duty of disclosure is an important aspect to consider. In English law, looking back at the case facts, Charlie checked the manual to see if the CB3 model suited HLB's purpose, and this manual was also checked by Bob. It is therefore based on his own inspection of the information in the manual that Bob decided the CB3 model was suitable. However, a question then arises on whether or not Bob had a duty to discover the truth of the representation. The short answer is no. In Redgrave and Hurt, similar to in Bob's case, the defendant did not investigate the information as to its truth. Ultimately, the courts found that the defendant was not under a duty of diligence to discover the truth of the misstatement. So the effect of false representation is not gotten rid of on the ground that the person to whom it was made has been guilty of negligence. Therefore, Bob is not liable for the misrepresentation. Now that misrepresentation becomes the issue, consequently, does Charlie then owe a duty of disclosure on the mistake in the manual regarding the correct lifting capacity? Generally, there is a duty not to misrepresent, but there is no duty to disclose material facts known to one party of a contract but not to the other before or at the time of making the contract. However, if an information has been asked for, then there is a duty to disclose the truth. Bob informing Charlie on the specifications of the model required and checking the manual can be inferred as him asking for information to confirm his decision. As such, Charlie did have a duty to disclose the truth. And true enough, Charlie did make the statement on the information to Bob, truthfully as he found it in the manual, and it is important to note that up until this point, the information is held to be true. However, Charlie later finds out that the information he provided to Bob is now untrue, and in such circumstances where a statement was true when it was made and becomes untrue due to a change of circumstances, there is a duty to disclose the change in circumstances which rendered the representation false. So referencing the case of With and O. Flanagan, it was held that the plaintiff was entitled to rescind the contract on grounds of misrepresentation. Therefore, Bob now has a cause of action under misrepresentation in English law. Now, in Malaysian law, the rule on duty of disclosure follows closely the English law standpoint. In the case of Lau Hee Tia and Hargill Engineering, so the federal court held that the contract between the parties was not voidable for material non-disclosure of facts. The general rule applied here is caveat emptor, which is the principle that the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. However, Section 18 of the Contracts Act 1950 can be inferred to cover the situation where a true statement is made but it becomes false to the knowledge of the maker before it has been acted upon. So applying this to the case facts, Charlie had a duty to disclose the change in circumstances, and his breach of that duty could give him an advantage, which is that he gets to sell his crane models by misleading Bob to his prejudice. So despite there being misrepresentation, in Malaysian law there is a duty imposed on the representee, Bob, to discover the truth of any representation made to him. And this applies through the exception to Section 19, which provides that if consent was caused by misrepresentation, the contract is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. So in the case of Tonne and Eastern Mining and Metals, the federal court held that although there was misrepresentation on part of the plaintiff's agent during the pre-contractual negotiations, the defendants on the facts could, with ordinary diligence, have discovered whether the representation was true or false. However, in Bob's case, it can be inferred that there was no ordinary means for him to have verified the truth of the statement in the manual, as the cranes were new on the market and had not been sold before. Therefore, the exception does not apply to Bob. So, in essence, in order for a misrepresentation to be actionable, it must be false or untrue. The representation by CBT was false, as established above, as Charlie failed to disclose the correct information regarding the carrying capacity of the cranes.
The next element is that the misrepresentation must have been made known to the party misled before or at the time the contract was made. Applying the facts of the case, Charlie recommended the carrying capacity of the crane to Bob prior to the making of the contract. Thus, this element is fulfilled. The last element is that the misrepresentation from CBT must have induced HRB to enter the contract. To prove this, HRB must have knowledge of the existence of this misrepresentation and that it affected his judgment in entering the contract. In this case, Charlie recommended the cranes to Bob, who then read the incorrect manual and thus made a decision to purchase the cranes based on the misrepresentation of the carrying capacity that was not corrected by Charlie as he should have. Therefore, it can be concluded that HRB relied on CBT's misrepresentations of the incorrect carrying capacity when entering into the contract with CBT, and it materially affected their judgment, as emphasized by Charnock R. When misrepresentation is established, the aggrieved party may seek damages or rescission.
Greetings, Mr. Hasharan. My name is Hanis Marisa, and I will be explaining the elements to fulfill misrepresentation under Malaysian law. In addition, to establish misrepresentation under Malaysian law, the elements required are similar to English law. As in English law, if there is no causal link between fraud or misrepresentation and the entry into the contract is not voidable. HRB firstly does not know of the existence of the misrepresentation. According to the case of Weta Construction v. Kusigan Berhad and another and Law Woon Inc. 1981, if the representee relies on his own judgment, the misrepresentation of the representer cannot be said to induce him into the contract. Here, Bob purely relied on the information in the manual that Charlie gave him as well as his recommendation. No further investigation or third-party expertise was relied on by Bob. Lastly, there is no causal connection if the representee knew or ought to have known that the representation was false, as seen in Afin Bang Berhad and Muhammad Qasim Abdullah Kamal bin Ibrahim, 2018. Here, number 1, CBT3 cranes were new on the market, not had been sold up at that point in time. Number 2, CBT3 cranes are manufactured overseas. And number 3, the manuals and Charlie both stated the carrying capacity to be 3 tons. Therefore, Bob, as a mere engineer, would not have known the true carrying capacity of the cranes. The next analysis on this case will be the type of misrepresentation.
Under the English law, the definition of innocent misrepresentation can also be seen in Smith and Land and House Property Corporation. The court established that innocent misrepresentation occurs when a false statement is made honestly, without negligence and with reasonable grounds to believe in its truth. This principle is mirrored in Malaysian law, specifically under Section 18 of the Contracts Act 1950. And turning to the present scenario, the initial representation made by Charlie's Block and Tackle CBT regarding to lifting capacity, the CBT3 cranes, can be regarded as an instance of innocent misrepresentation. Both under English and Malaysian law, CBT genuinely believed, based on the information provided in the manuals, that the cranes could lift weights of up to 3 tons.
Continuing on the part of the different types of misrepresentation, the previous discussion on CBT's duty of disclosure casts a speculative light on this case being one of innocent misrepresentation, which brings us to negligent misrepresentation. So established in the case of Hedley Byrne and Heller, The case highlights that the liability for negligent misrepresentation arises when, number one, the defendant carelessly makes a false statement to the claimant. So in examining this factor, it is worth noting that Charlie did not initially carelessly make a false statement. He had honestly believed the information provided to Bob to be true and had reasonable grounds for believing in its truth because it was based on the manual. However, this position changes when Charlie gets the email that clarifies the information he had provided Bob, and now he owes Bob a duty to disclose the changes in the circumstance. So this can be inferred as Charlie's carelessness to correct the information provided to Bob, thereby making it a false statement. So the second thing to consider is that circumstances are such that it is reasonable to assume that the statement would be relied on. So it is reasonable to assume that Bob would rely on Charlie's information on the specifications of the crane model. And the reason being is Charlie sells a range of heavy-duty cranes and would therefore have knowledge on the specifications of the crane. Moreover, Bob's action of informing Charlie of the specifications can be inferred as Bob relying on Charlie to recommend him a crane that met his specifications. The third element is the false statement is relied upon. And true enough, Bob does rely on Charlie's misstatement when he decided to confirm the crane after looking through the manual. The last and final element is that there is a special relationship between the parties. So CBT is the seller and HLB is the purchaser, and both of them signed a contract for the sale and purchase of 2 units of CBT cranes, and thus they have a contractual relationship. This special relationship here exists due to the fact that Charlie has special knowledge or skill in relation to the subject matter of the contract as established in Harris and Wire Forest District Council. So Charlie can be considered as having special knowledge in cranes as he owns a business selling heavy-duty cranes and can reasonably foresee that the other party, which is Bob, will rely on his statement. And this is laid down in the case of Chaudhary and Prabhakar. Bob specifying his requirements to Charlie is an indication of him relying on Charlie's expertise to provide him with the best crane that fits his purpose, and as such, it is reasonably foreseeable to Charlie that the information provided by him will be crucial to Bob. So considering the factors above, it can be deduced that by being absent-minded, Charlie had been negligent, and as such, Bob would have a cause of action under negligent misrepresentation in English law. Now, in Malaysian law, as discussed under the duty of disclosure, Section 8 covers situations of common law negligent misrepresentation, and although unclear, it can be inferred that a breach of duty to disclose the change in circumstances, rendering the statement false, can amount to negligent misrepresentation. Further, Malaysian courts have adopted the common law decision in Hadley, Byrne and Heller by recognizing the tort of negligent misrepresentation.
Good day, Mr. Hacharan. My name is Elise, and I will be talking about remedies available for HLB in English law and Malaysian law. A contract that has been induced by negligent misrepresentation still confers obligations upon the parties, but it is voidable at the option of HLB, who is the innocent party. Therefore, the first remedy that HLB can opt for is the remedy of rescission. If HLB opts for the remedy of rescission, the contract will be terminated and CBT, the seller, is able to obtain restitution of the property sold. HLB can return the 2 cranes to CBT, and CBT will also have to return HLB the £100,000. For according to the case of Islington LBC and UCKAC, it is sufficient for HLB to give notice of rescission to CBT to rescind the contract, as an order of court is not necessarily needed. In order for HLB to seek the remedy of rescission, they will have to ensure that none of the bars of rescission apply to them. The first bar, affirmation of contract, in this case, after discovering the actual carrying capacity of the cranes, HLB did not continue using it and instead sought to sue CBT. This shows that their actions did not affirm the contract further actions. The second bar, intervention of third-party rights, also does not apply here, as the cranes did not go into the hands of a bona fide purchaser for value. Thirdly, the bar of unreasonable delay is irrelevant here, as HLB is seeking to sue CBT as soon as the incorrect carrying capacity of the cranes were discovered. So no unreasonable amount of time has passed between the discovery of the misrepresentation and the action. Lastly, restitutio in integrum is possible in this case. The parties are able to be returned to their pre-contractual positions. There's no information on if the money has been used, hence it is assumed to be payable back to them. In conclusion, none of the bars of rescission apply to HLB, therefore he still has the right to rescind. Next, damages for negligent misrepresentation will be talked about. However, ever since the case of Hadley Byrne, it was established that negligent misrepresentation can give the innocent party the additional right to bring an action in tort for damages of financial loss. HLB can claim damages for negligent misrepresentation for all losses caused by the negligent act or omission, but for only those which are reasonably foreseeable as established by the case of the Wigan Mount No. 1. Owing to the negligent misrepresentation of Charlie on the incorrect carrying capacity, Bob made the decision on behalf of HLB to purchase the CBT 3 cranes. This ultimately resulted in the cranes being unable to carry the weight represented by CBT and hence dropped a 2-ton concrete block onto the glass roof of the building of the project and destroyed it. It is thus reasonably foreseeable that the misrepresentation would have caused damage of this kind and that HLB would have to then bear the damages, in this case, worth £500,000. Other than the common law cause of action, HLB may opt to bring an action under Section 2, Subsection 1 of the Misrepresentation Act 1967. This section applies only to parties to contract, misrepresentations that induce entry into contracts, and non-fraudulent misrepresentations, all of which HLB and CBT satisfy as established earlier in the elements required to establish misrepresentation. Legal scholar Richard Hooley analyzes that section reverses the burden of proof in favor of the innocent party. HLB only has to show that the statement from CBT was false, and CBT then carries the burden to prove that he had reasonable grounds to believe and did believe in the truth of the representation up to the time of making the contract. In Malaysian law, the first possible cause of action lies in Section 19, Subsection 1 of the Contracts Act 1950, which makes an agreement caused by misrepresentation voidable at the option of the innocent party, which is HLB. Section 65 then goes on to say that the party rescinding, in this case HLB, must restore the benefit received, which is the 2 cranes from CBT. Section 66 then necessitates that any party who received any advantage must restore it or make compensation. Therefore, CBT also has to compensate HLB the £100,000 he received from HLB as payment. To pursue this cause of action, HLB may apply to court for rescission under Section 34, Subsection 1A of the Specific Relief Act 1950, or simply give notice of rescission to CBT. Next, damages in common law are also available in addition to rescission, as stated in the case of Abdul Razak bin Datuk Abu Sama and Shah Alam Properties. However, the case also emphasizes that damages must take into account any sum recovered as restitution under the claim for rescission to prevent double recovery. Now, in assessing damages for negligent misrepresentation, the remedy lies in damages in a tort of negligence and applied in Nyong Su Or and others against G. Retinasamy. The elements that have to be proved by HLB to succeed under common law are similar to that of English law. A third possible remedy lies in Section 19, Subsection 2 of the Contracts Act 1950. This section allows the innocent party, which is HLB, to affirm the contract and require the law to put parties in a position as if the contract had been performed. The assessment of damages will hence be based on the contract basis.
In conclusion, this case is one of misrepresentation. All of the elements misrepresentations have been proven for both English and Malaysian law. Although Charlie initially innocently relied on the incorrect information in the manual, this innocent misrepresentation became one of negligent misrepresentation when he failed to perform his duty of disclosure. In terms of remedies in English law, it is highly advisable for HLB to make a claim under Section 2, Subsection 1 of the Misrepresentation Act 1967. Contrary to common law, no negligence has to be proved. They only need to prove that the statement made by CBT was false. As emphasized by legal scholar Kristen Doyle, the representee from HLB can claim simultaneously under the Misrepresentation Act and in contract, but they will not be able to recover twice for the same losses. Consequently, HLB is entitled to rescind the contract and return the 2 CBT 3 cranes to CLB while recovering all losses, specifically the £1 million from the failed project, the £500,000 paid to WLC, and £100,000 paid to CBT. Under Malaysian law, it is more advisable for HLB to rescind the contract, returning the cranes to CBT, with CBT returning them £100,000, and bring a cause of action under common law of negligent misrepresentation to recover the £1 million from the failed project and the £500,000 paid to WLC. For the reason that HLB will be able to recover more in the contrast to pursuing a cause of action under Section 19, Subsection 2 of the Contracts Act 1950, It is thus evident that as a Malaysian law lacks a statute such as the Misrepresentation Act 1967 in English law, the English law position is one that favors the innocent party and places the burden on the representer